Welcome to LexiCast, a podcast designed to help you grow in your legal practice, with weekly updates on current topics, trends, and practical insights. Perfect for listening on the go. Let's dive in. Okay, so here's a stat that should stop you mid-scroll. 83% of Victorian lawyers have either experienced or witnessed uncivil behaviour in their workplace in the last 12 months.
83%? That's not a few bad apples number. That's a this is the culture number.
Exactly. And it's one of three big shifts we're unpacking today, because none of them are theoretical anymore. Regulators have caught up with AI use in the courts, psychosocial safety just became an enforceable legal duty, and the billable hour is quietly losing ground faster than most partners want to admit.
Welcome back to the Quarterly Pulse, where we take everything that happened in the legal world over the last 3 months and turn it into something you can actually use.
And 2026 gave us a lot to work with, so let's get into it.
Start with AI, because I feel like every quarter we say, this is the quarter AI gets serious, and then it gets even more serious the next quarter.
This time it's real though, because it's not guidance anymore, it's practice directions, binding or quasi-binding rules from the courts. The Federal Court's GPN AI came into effect on the 16th of April this year.
What does that actually say?
In plain terms, your use of AI has to be consistent with your existing professional duties. It's not a new set of rules bolted on top, it's your same duties. Competence, honesty to the court, diligence, just now with AI use specifically in the frame. And if you don't comply, you're looking at adverse costs orders.
So the court can make you personally pay costs because you didn't check your AI output properly.
Correct, and it's not the only one. The FCFCOA, that's the Federal Circuit and Family Court, brought in its own AI practice direction on the 29th of May. That one's stricter again because family law material is sensitive. Practitioners have to be able to explain how the AI tool was actually supervised.
Explain to who though? Like, is a judge going to ask, hey, talk me through your AI workflow?
Potentially, yes. If it comes up, you need to be able to walk through it. What tool, what task, what checking process. And going back a bit further, the New South Wales Supreme Court's SC Gen 23, that's from February last year, already restricts generative AI in affidavits and witness statements specifically, and requires written confirmation when it's used.
Written confirmation of what? That you didn't just let the AI write someone's evidence?
Pretty much, that a human has verified the content, which reflects what the witness actually said. And here's the line that matters most out of all of this. Hallucination is not a defense, full stop, in any jurisdiction that's spoken on this.
Which feels obvious, but people keep testing it anyway.
Yes, people keep testing it anyway. There have been enough cases globally now of lawyers filing AI-fabricated citations that courts are done being lenient about it. You file the document, you own its accuracy. That's the whole doctrine in one sentence.
What's interesting is you said multiple courts, but not all of them.
Right, good catch. The High Court hasn't issued a practice direction on AI yet, so there's still a gap at the very top. Doesn't mean you get a free pass there, your general duties still apply. It just means there's no AI-specific rulebook from the High Court yet. Watch that space.
Okay, so bottom line for anyone listening, if you're using AI for drafting, research, anything court-facing, you need to know which court you're in and what its specific rule says.
And build in a verification step every single time. Not, I skimmed it, an actual check against the source material.
Noted. Now, the psychosocial safety piece, that 83% stat from the top. Walk me through why that's suddenly a legal issue and not just an HR issue.
Because the regulators decided a policy document sitting in a drawer isn't compliance anymore. Victoria's OHS psychological health regulations commenced the 1st of December last year, and they require employers to actively identify and control psychosocial hazards, things like excessive workloads, bullying, incivility, not just acknowledge they exist.
So having a wellbeing policy on the intranet doesn't cut it.
No, it does not. You need to be able to show you identified the hazards and did something about the controls. New South Wales has moved too. Their code of practice is now admissible as evidence of what compliance actually requires. And SafeWork New South Wales has had dedicated psychosocial inspectors on the ground since March this year.
Inspectors, like people who can turn up and ask about your firm's culture.
Essentially, yes. And that 83% figure, that's from the Victorian Legal Services Board and Commissioner, is exactly why this stopped being a soft issue. When the regulator's own data says 4 out of 5 lawyers have seen or experienced incivility, we have a policy isn't going to hold up.
So what does a firm actually need to be doing differently, practically?
Treat culture like you'd treat any other compliance risk. Identify where the pressure points are. Is it a particular practice group, a particular workload pattern? Put controls in place and keep evidence that you did it. Not a value statement, data, actions. A paper trail that shows active management.
It's the same logic as any other risk register, just applied to how people actually feel at work.
Exactly that.
All right, third one, billing. This is the one I think every junior lawyer secretly wants to talk about because we've all done the 6-minute unit dance.
The 6-minute unit dance. I like that. So here's the driver. AI is compressing how long routine work takes. And when the task takes a fraction of the time, hourly billing for that task starts to look a bit indefensible to clients.
Right, because if a memo used to take 3 hours and now takes 40 minutes, charging the old rate doesn't sit well.
Clients have clocked this. A survey of Australia's top firms found 87% now offer some kind of billing choice. Fixed fee, capped fee, something other than pure hourly. And it's changing firm structure too. Minter Ellison cut its graduate intake from 104 down to 72, and they said directly that AI absorbing routine work was part of the reasoning.
That's a huge number to attach to one cause.
It is, and it's worth sitting with, especially if you're early career. We'll come back to that. But on the billing side specifically, here's the compliance reminder. Fixed and capped fees still sit under the legal profession uniform law, and your cost disclosure obligations apply exactly the same as they would for hourly billing.
So switching to a fixed fee doesn't mean lighter disclosure requirements.
Not even slightly. If anything, be more careful, because you're pricing an outcome rather than time, so you need to be crystal clear with the client about what's included and what isn't.
Price the outcome, explain it properly, disclose accurately.
That's the whole formula.
Now, beyond those 3 big ones, there's a handful of things the profession's been talking about non-stop this quarter. Can we do a quick lap of those?
Quick lap, yes. Tax law first. Practitioners are calling this the most consequential stretch since the GST came in, mostly post-budget pressure hitting SME-focused firms hardest.
Who's feeling that specifically?
Definitely commercial and tax practitioners, and small to medium firms with a lot of SME clients asking, what does this mean for me, all at once?
Next.
Litigation. Australia's leaning further into being one of the most litigious environments globally, evolving class action frameworks, rising civil penalties, more employee claims. Employment lawyers and in-house counsel are the ones feeling the heat there.
And AML CTF. I know this one's been loud.
Very loud. The Law Council actually lobbied to delay Tranche 2 by a year, and it didn't matter. Obligations commenced the 1st of July this year regardless. Smaller firms are under the most pressure because they've got the same obligations as the big firms, but a fraction of the compliance resourcing.
If you're at a small or mid-sized firm listening to this and you haven't checked your AusTrack enrolment,
if that is you, you need to do that this week. Confirm enrolment. Confirm your compliance program is actually built, and confirm you've got a nominated compliance officer. Not, we're getting to it.
And then there's new law.
Yes, new law's basically gone mainstream. Hybrid, fractional, tech-driven firm models aren't the alternative path anymore. They're just a normal path, because clients are demanding specialised, competitively priced, unbundled services. So if you're a firm principal, the competitive question isn't, should we worry about new law? It's, does our current model actually hold up against it?
So across all of this, AI, safety, billing, tax, litigation, AML, new law, the thread is basically the same. The ground's moving faster than firms are used to.
That's the 12-month outlook in a sentence, actually. Momentum is rated high and rising. This isn't a settle back down next quarter situation. This is the new baseline for planning your next financial year.
All right, let's land this for the listener. What are the 2 things they should walk away and actually do?
First, audit your AI use against whichever court's practice direction actually applies to your matters, and make sure verification is a built-in step, not an afterthought. Second, if you're in a leadership role, go check whether your psychosocial safety approach is actually active hazard management, or whether it's just a policy sitting on a shared drive, because that gap is exactly where the regulator is looking right now.
Verify your AI output and stop treating culture as a nice-to-have.
That's it. They might seem like small actions, but they're the ones that keep you out of trouble.
And if you're just starting out, You own verification. Never file AI output unchecked. Psychosocial safety is a duty, not a perk. And go find yourself varied, supervised work while you can, because the routine stuff is exactly what's shrinking.
Good place to end it. Check the episode notes for our quarterly Pulse blog article, and we'll catch you next quarter for whatever's moved by then.
Which, at this rate, will be a lot. That's it for today's episode on LexiCast. If you're looking for more in-depth episodes that can also be claimed as CPD activities, check out our LexiCast CPD page, linked in this episode's notes. Follow us now to stay up to date, and we'll see you next time.